Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another exciting episode of our show. Today, we are talking to James Long of Atlantis Law. James Long is a estate planning attorney, also practices trust administration, litigation, and bankruptcies. James, welcome to the show.
Hey, thanks for having me, Matias. It's great to be here.
Thank you. And you know, I'm going to ask you the first question. It's like, why Atlantis Law? This is what I wasn't planning on asking you that, but your website is atlantislaw.com. And would you mind sharing with us why is it called Atlantis Law?
Sure. Unfortunately, I probably don't have a good answer for you. I bought the law firm from another lawyer who had named Atlantis Law. So, you know, in my own mind, I like to think that he named it Atlantis, maybe because it's bankruptcy and estate planning. So if you don't want your estate to get lost, like the Lost City, call us or something like that. But I never really asked him why he named it Atlantis Law, but he had been doing business for like 30 years under Atlantis Law. I bought it and I kept it. So there you go.
Beautiful. That's a good story. All right, let's delve right into our topic, which is estate planning. James, why is estate planning important?
Yeah, I mean, you know, estate planning's probably the number one most important area of law, because it's an area of law that's going to touch everybody. You know, not everybody's going to get sued. Not everybody's going to have a car accident. Not everybody's going to be arrested or something like that. But everybody's going to die at some point. And everybody, when they die, is going to have something. And unless you do some kind of estate planning, the government gets to decide where it goes. So, you know, it's important because it's an area that touches everybody's life. And unless you engage in it or engage with it, the government gets to decide what happens. And to my mind, I think that's, you know, maybe not always the best circumstance. So it's super important for people because oftentimes it's the most neglected area because people think they live forever. But it's an area that it touches everybody.
Absolutely true. Thank you for sharing that. Let me ask you, what in your practice or when you talk to people, you know, as an attorney and as an educator, as you share your knowledge, what are some of the misconceptions that you've come against when you talk to somebody about estate planning?
Yeah. So number one misconception would probably be that you've got to be rich to do it. Right? You've got to be millionaire. You've got to have all these assets. And that's just not true. The second thing I think probably is that I'm too young. Right? I don't need to think about that until I'm old, until I'm about to die, or until I retire, or something like that. Yeah. So it's sort of excuses you make to kick the can down the road. And in reality, you know, if you've got young kids, you better do it because you better name guardians. And if you're about to retire, you better do it because that retirement's going to go somewhere. So, you know, the first myth, again, I'm not rich enough. Second myth, I'm not old enough.
Right.
Yeah.
So I guess, you know, if as a follow-up question to what you said, there isn't really a perfect age to get started other than the fact, like you said, I mean, if you have kids, that's the reason to do it. I remember, this is a funny thing. I was crossing the street with a friend and they were like, oh, wow, that car kind of came pretty close. I hope you have life insurance.
Yeah.
And I was like, oh, you know, I have 4 kids. You're right. I need to, this is years ago. And I was like, and I ended up getting life insurance just because, you know, that was, you know, one of the things. So estate planning kind of is just as important, of course. So my question to you, I guess, in relationship to you know, these misconceptions is when somebody wants to get started, what are some of the barriers that, or some of the things that people have to say, okay, this is what I got to do. James, let's do my estate plan. Okay, what do I do now? What am I supposed to tell you? Just everything I own? Am I supposed to, like, how's your onboarding process, I guess?
Yeah. You know, we try to make it as easy as possible for people because a lot of people get, I guess, overwhelmed by, I've got to have an inventory of this and I got to know every bill I pay. I got to know everything I have and every account number and this and that. And, you know, to start the process, we try to just kind of keep it simple. what generally do you have, right? Meaning, do you have a house? Do you have life insurance? Do you have accounts? Generally what you've got. About how much is it all worth? Okay. And usually I ask that client, that issue of clients, is your estate over or under $5 million? And that's the magic number because, well, at least right now the exemption is $12 million. That means that's the limit for where you start having to pay estate taxes.
Right.
That goes down to like 5.5 million in 2025.
Right.
So I just say, is your estate over or under 5 million? And then that's a yes or no question. So it takes some of the work out or the stress off of folks. You don't have to come up with an exact dollar to cent number. We just need to know, is it over, under, and generally what you got. And then the final component is, where would you like all that to go? Like what's going to happen? And so if we frame it in those big kind of chunky components, it's less intimidating for clients and it creates less of a barrier because it's easier to think about, okay, well, I have a house, I have this, I'd like that to go to my kids. It's under 5 million. And now we can start getting into details about, okay, well, here's the type of trust you need. Here's how we can make what you have or what you want a reality.
That makes sense. Now, you brought up taxation, which obviously, death and taxes go hand in hand. So, so I appreciate that. And one of the things that I wanted to ask you about, new laws, like you mentioned that, it's 12.5 now, it's going to go to 5 and change in the future. What are the things, whenever these new laws happen, for instance, so let's say you did somebody's estate plan whose estate is over 5 million, when the exemption was 12.5. Now, in 2025, the law is different time. Things are changing. Are you reaching out to these people proactively and saying, look, we got to do something. We don't have an exemption like we thought before. You better figure something out unless you want to pay. Because I think the estate tax is quite steep.
Oh, yeah. It's about 50 cents on the dollar. So it's, generally, right? But here's what we do. Maybe one thing that makes my firm a little bit different is that not just the clients who have high net worths, but we reach out every 3 years to all of our clients. And it's sort of a simple letter saying, hey, it's been about 3 years since your plan. Have you moved? Do you still like your kids, right? Is there anything we have to, do we have to disinherit anyone? Is your estate over or under? Here's the current exemption, right? Have you increased in value or decreased in value? Do you still like your trustees? Is anyone addicted to drugs? Has anyone developed special needs? These sort of triggers where, if they answer yes to these questions, maybe we should amend. In particular, for the 2025 issue, we're going to be sending letters to everybody, not just the people in that 3-year window, but saying, hey, this is going down. If your estate is over that, or you anticipate it to be over that at the time you pass, there's some things we could do to protect you now. So let's have a meeting. Let's have a conversation about it. So, we're pretty proactive at my firm in the sense that we, just as a matter of practice, always stay in touch with our clients because as a moral proposition, I want to know if I've done a plan for someone that it's going to work. And I know, like, when they leave my office, I know it'll work. I don't know what's going to happen when they leave. And so in order to know for sure, I've got to keep up with them and make sure that they haven't refinanced and accidentally taken a house out of trust or something like that. Or they haven't won the Powerball jackpot, right? And you forgot to tell me, that kind of thing. So we reach out to our clients, particularly in 2025, the ones we know for sure will have a problem, and we kind of let them know what's going to happen.
Yes. Let me ask you a question about, we talked about taxation. We thought about how things changes. And you said, if you reach out to somebody, you will tell them, hey, if your estate is going to be worth more than X, there are some things I can do to help. Let's talk about those things. What are those things for high net worth individuals that they should be preparing to do in order to, safeguard some of their assets?
Right. So the exemption that we're talking about is sort of the lifetime exemption. And I like to frame it like everybody has right now about $12 million you could give away during your life to anybody you want. And when you give that to that person, it's tax-free. Right. And as you give those gifts away, it reduces that lifetime amount. Now, most of the time, you keep a hold of your estate and you gift everything after death. But you can make a gift during life and still use that up. So, there's a bunch of different types of irrevocable trusts, intentionally defective grantors trusts, life insurance trusts, family limited partnerships, all sorts of mechanisms where you could potentially gift a portion of your estate now while you're alive to an entity or another trust that you might have a little bit of control over or could benefit from, use up the exemption you're going to lose. For example, if you have a $12 million estate, you could gift $6 million to a separate entity, use up that exemption, get that part out of your estate, retain some control, and then, plan for the rest of your estate with the remaining balance, and kind of go there. So everything's different. It depends on the circumstances, but things like family limited partnerships, intentionally defective grantors trusts.
That one I've heard about charitable remainder trust. I've learned about a lot of trust, but what is intentionally defective grantor trust? Is that what you said?
Yeah. So sometimes it'll be called like an IDGT trust. That's the IDGT. IDGT. That's a type of irrevocable trust that you can use usually in conjunction with maybe like a family limited partnership or something like that, where you retain a little bit of control, maybe to pay the taxes, so basically what that means is for taxation purposes, it's a grantor's trust, right? So, but it's an irrevocable trust, but it's defective in the sense that you've retained a little bit of power, making it a grantor's trust. So you still have some power, but it's irrevocable for the purposes of transfer. So that the gift is treated as a gift that day, but you still retain some of the control over the asset, if that makes sense.
Yes, that makes total sense.
Yeah.
Thank you for explaining that. Let's talk about communication. You mentioned, when you reach out to people, you still like your successor trustee, and you still like all of your kids and all of those things. So how do you help your clients communicate, with their family to understand what they're doing?
I think that's a tough one. Because everybody has every client, has their own particular sense of privacy. Okay. Right. So some clients are just naturally more private than others, and that's okay. I say when I do a signing with clients, I say in almost every signing, as inclusive as you feel comfortable, that's how inclusive you should be. Right. I do a lot of trust litigation as well. And sometimes a lot of the breakdown, fighting and lawsuits get filed not because something actually went wrong, but because there was a breakdown in communication because one kid thought I was supposed to get this and I didn't know I was disinherited or I didn't know this. Right. If the family's just upfront and says, hey, this is what's going to happen, sometimes that limits those kinds of fights later on. And it could be an uncomfortable conversation for clients because they don't want to say like, hey, you're getting disinherited or you're not getting the car you wanted or whatever it might be. And so I just encourage clients, be as open and inclusive as you can. Certainly make sure your trustees are willing to be your trustees. You don't, if you, at the bare minimum, you need to let them know that they're named. Right. At a bare minimum, someone needs to know where your stuff is. Right. Because I get calls maybe 3 or 4 times a year. Hey, my parents had a trust. No one knows where it's at. No one knows. Yeah. We know they have a trust, but they were super secretive. And that doesn't help anyone. So at a bare minimum, someone needs to know where it's at. Someone needs to, the trustees need to know that they're in charge. And then, to kind of help that a little bit, we retain copies of all of our clients' documents in our system. And so when you record a deed, I'm sure as a real estate guru, you recorded a deed to a house and it'll say recording requested by when, recorded mailed property tax statement. So when we record a deed for a client, it'll say recording requested by Atlantis Law Firm. It'll have our address and our phone number. So at a bare minimum, someone will know it's in a trust. Someone will know that our firm requested that. Hopefully they'll reach out. And if they can't find anything, our numbers are going to stay the same. Our address might change, but our phone number will stay the same. They can call and we can say, well, you're in luck. We have a copy and we can get it to you. If that type of stuff happens, but, for if anyone's listening out there and wondering, should I tell my kids that we have a trust? Tell your kids, be as open as you can, as you feel comfortable. Your estate plan is not going to be invalid if you're not telling people about it, but it really helps if you do.
That makes total sense. Thank you. You mentioned disinheritance. I talk to a lot of attorneys, and there are different philosophy out there for disinheritance. Leave them something and leave them enough so they don't contest, but don't leave them too much so they have money to litigate, or the no contest clause, et cetera, et cetera. I'm just curious, what's your philosophy on disinheritance especially when it comes to children?
Yeah, every trust that I draft has a no contest clause, which basically says if you contest the trust without due cause, right? That's what the law says. Without due cause, without some sort of reason for contesting, then you're kicked out.
Right.
Well, if they're not getting anything, that clause really doesn't mean anything. If they're getting zero, they have no reason not to challenge the trust.
Right.
So, as a litigator, a client comes into me and they say, should I challenge the trust? If they're not getting anything, they have nothing to lose.
Mm-hmm.
But as an attorney, if someone comes to me and they say, should I challenge the trust? Here's why I think we should do it. And I see they're getting $10,000. I've got to tell them, listen, yeah, we could challenge it, but you'll probably lose that 10,000. And I think you shouldn't. I think you should take the 10 and go. By the same token, you shouldn't leave enough to litigate, right? Don't give them enough money where now you've just paid for the lawsuit. Give them enough where they feel like it'll hurt if they lose it. So, I've seen trusts where it's like he gets $1 and nothing else. Well, that's a bit about giving them nothing. That means nothing.
Right.
And again, every client's different, because I got some clients who are like, if I have to give that child of mine any more than $1, I'm going to throw up in my mouth. Okay, well, here's the risk. Don't throw up in your mouth. Do what you want to do, and I'll do it. I just got to tell you what you're risking. And I try to kind of get them to a point where they could make the no contest clause worth something,
That makes sense. Thank you for sharing that. I like your philosophy on this. Let's talk about some challenging cases now that you've encountered, whether it be as a litigator or in the administration or estate planning process. Can you share some of those stories with me?
Yeah. So there's one case that's just real not nasty. It's just complicated. What underscores why you should do estate planning that we've got going on right now. Clients' great grandparents owned this property. Mm-hmm. Okay, they were married and they died, and then great grandpa remarried, and then he died, and nothing was ever done. But then grandpa quit claims everything to the next client, quit claims everything to the client, and now the client's trying to sell.
Okay.
And escrow comes back, title comes back and says they don't hold title. They have this quitclaim deed, but this guy never had title because no affidavit was done up here in the first marriage. And so we've got to go back like three generations and unwind this entire mess. We've got to do intestate succession there. And then we got to show that he had the full interest and that she disclaimed this. And complicating matters, the second wife of the great grandpa executed some sort of document saying, I give everything to grandpa, and recorded it on the property. But like, what value is that? I mean, we can say, okay, the house, so we've got to try to probate that. Is that a will? What do we got to do? It's just a mess. And it's been a long time. They've lost several buyers. And, the upshot is, if they just took some time to talk to an estate planning lawyer, they could have caught this. Yes. And they could have, found while people were still alive and could have done it.
Yes,
they could have fixed it. But now, it's so far, it's been almost a $17,000 problem for the client, because we've got to litigate and do all these cases to unwind it. And it's just been a problem.
Well, I'm going to add something to that. I'm also going to blame the realtor, whoever, if they lost buyers, I'm going to blame the realtor, whoever they are, because you got to order a prelim. With these cases, all the time, I tell this to everybody, order a preliminary title report prior to listing the property. Make sure you have insurability of title, because the title company will tell you, are you missing a death certificate? Are you missing this? They will tell you what they need to do a clean transfer of title. So if you do it prior to listing your property on the market, then boom, you got clear. You call James, he clears it out for you. Then you go on the market, and you only have one chance to do a first impression. Now, when people get a feeling that the property's got something wrong with it, whether it's title, whatever, people smell the blood, and they will say, oh man, you got this title is going to take months to clear. I'm going to give you $100,000 less, $200,000 less. So it's very, very important to make sure, first of all, and I see these all the time, first of all, make sure that the right person is signing the listing agreement. Don't just assume because they tell you they own the house that they can't, or the property, whatever the commercial asset it may be. So thank you for sharing that story, because it gave me a chance to pontificate about one of my pet peeves.
Yeah, and that's so important. It's like in my office, if someone says, I own the house, I do a title check. I check the title to see, do you actually own it, or did something happen? And only one time did I check the title, and it was like, you don't own your house. This other person owns your house, and it was her daughter. And what happened was she had remarried, but before remarriage, the daughter forged a deed.
Oh wow!
So because she was worried that the husband would get it. And so, we found the daughter had stolen the house from her, and we had to unwind that and get control. But But yeah, sometimes they think they own it and they own part of it, but not the whole thing because someone helped them get the loan and was on title, but they didn't know. And it's just, yeah, you got to check it.
You know, James, I had somebody, one of my guests said on the show, they asked the question, do you know what the easiest thing to steal from someone is? And the answer was their house.
Oh, yeah. Yeah.
And it was talking about forged grant deeds and forged quit claims and all those things that go with it. Thank you for sharing that story with us. Now let's talk about your journey. I think one of the things that my audience love is to learn about where the people come from, how they made it to where they are today. So did you want to be an attorney when you were a little kid?
I did. My mom was a legal secretary, so she was always around attorneys and things like that. And I loved their offices. Mm-hmm. I loved all the paperwork. I loved all that stuff. Now I hate paperwork. I still like my office. I have a great office, but I hate paperwork. But I wanted that. I wanted to be a lawyer. My mom didn't want me to be a lawyer because she worked for them. So she knew how scummy lawyers could be sometimes. So when I told her I was going to law school, she about wept. But you're too nice. You can't be a lawyer. No. She didn't want it for me. She was very upset.
But then you decided to go to law school. And what had you gravitate toward the kind of law that you practice now?
Yeah, well, so my journey is maybe not unique, but everybody has a unique journey. So at one point I was going to be a Catholic priest. Okay. So I was in seminary for 4 years, was going to be a priest, decided that probably celibacy was not my jam. And then met a girl at church and confirmed, no, that's celibacy isn't for me. That's not what I'm going to do. But so I ended up going to law school because as part of the seminary process, you take philosophy. So I had this degree in philosophy and you're like, what do you do with a degree in philosophy? You go back to school or you go be a teacher. Like that's what you could do. And so I thought, well, I'll go back to school. I've always wanted to be a lawyer. Philosophy kind of feeds into that. Let's do it. And there was also this kind of sense, it's kind of cliche and maybe a little bit, I don't know, just cliche to say like, I wanted to help people, right? Because I had this sort of sense of mission and vocation and things like that. So I went to law school with that sense. And then, I decided to go to University of St. Thomas in Minnesota because I thought I got accepted to the beach schools out here in California. And I decided that the Minnesota would be better because it was a Catholic law school, so I thought that would be good. But also the snow would make me want to study more. Yeah. So I thought I would just be in the library studying. And it turns out the library in the snow was just as distracting as the beach. So that was fine.
That's actually a really good story. I like that. I like your dedication. And you know what? It's an interesting calling to go from priesthood and having that, and then wanting to change, but with still maintaining the same drive, which is assist people. And in a sense, when you deal with your clients, I guess that's how you approach every interaction. Let me ask you a question. You went to law school. You went to Minnesota. You still managed to survive the snow. And then how did you gravitate? Was it in law school that you decided, you know what, I love trust and wills? That was a great class. That was my favorite class. Or is that something that happened later on? Yeah.
So my grandfather died when I was about 10 years old.
Okay.
And he and my grandmother had a trust. Okay. So, and the trust has just worked out very, very well for my grandmother. And she has this personal property list where every one of her kids has a color that's assigned, and they have these dots, right? So everything in grandma's house is dotted with the color of the kid that it goes to. And so going into law school, there was this sort of creative trust that I knew about, conceptually with my grandparents. And so when I was in law school and you were picking sort of, all right, what path are you going down? I was just kind of lean toward that because I don't know firsthand about how easy it was, but I remember as a kid thinking, oh, this is cool that grandma has a trust, that that's grandpa did something to take care of grandma in my mind. And so, I took the first trust and estates class I could. I did the taxation class. I did all that kind of stuff because I was just interested in it for personal family reasons. I didn't really think, oh, I'll be an estate planning lawyer. I kind of thought I would be a prosecutor, like a district attorney. That's kind of where I was wanting to go. Right. But I wanted to take these classes because I was interested in grandma's trust. I wanted to know about it and learn about it. And it was interesting to me.
Okay, so from priest to prosecutor, I don't see the connection. I see just a wide gap. From priest to estate planning, I kind of can make that connection. So thank you for sharing that story with us. Okay, so now I'm gonna conclude with the exercise that I love to do in every one of the episodes. I have a list of 30 questions, and they're all numbered between 1 and 30. And I want you to pick a number between 1 and 30, and I will ask you that question.
All right, number 7.
7. What sound or noise do you love?
What sound? My kids laughing.
Oh, that's a good question. Yes, that's a good answer. Very good answer. How many kids do you have?
I've got 4. I'm like you.
Oh, wow.
Yeah.
That's awesome.
Yeah.
I love, we are of the same spirit, a kin spirits.
There you go. Yeah.
Fathers of 4s. That's wonderful. Okay, James, I'm going to have your contact information in our show notes. But would you mind sharing with our audience, what is the best way to get a hold of you?
Yeah, so best way to get a hold of me through email. It's just my first name at atlantislaw.com, James at atlantislaw.com. But if you want to make an appointment or something like that, you can call the office line. Claudia is the one that handles my calendar directly. She's the best one to talk to. Believe me, if you called me directly, I would mess it up because I'll put something on my calendar and then she'll remind me that I'm already booked, and it's a mess. So I trust Claudia with that. She'll be the one that you would contact most likely. But if you wanted to ask me a question directly, you could shoot me an email and I'll answer it. It's not a big deal. That's probably the best way to reach out to me and ask a question or something.
Perfect. Thank you so much. It's been such a pleasure to have you on the show. Thank you for sharing your wealth of knowledge. And maybe we will plan to have you back. So I feel like we just scratched the surface. There's so much more we can talk about in this.
Yeah, I agree. And thanks for having us. It's been a lot of fun.
Yeah, absolutely. Okay. Bye, everybody. We'll see you in the next episode. Bye.
Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.